Welcome to Trial Lawyer Prep, where you learn to better connect with clients and juries, gather strategies to better persuade your audience, and use focus groups in the process. I'm your host, Elizabeth Larrick, and in this episode, I'm walking you through a trial where the judge tore up the schedule on day one, cutting our time nearly in half, and why I was thinking it was actually a gift, not a setback. We'll get you into how we prepped for a trial that was both engaging and bulletproof for appeal, even when the clock wasn't on our side. For trial, there's always a constraint on getting the verdict you want and making the evidence appeal-proof. The balance between presenting for a jury, think attention spans, engaging themes, framing, and creating the proper record for appeal, think documents, exhibits, specific facts from testimony, analysis to be testified about. Getting this is a challenge, and so this case that I was consulting on was no different. In fact, they had the opposing counsel who had already said on the record that he promised to appeal any verdict. So the gauntlet had been thrown. In response, the lawyers were building heavier outlines for their experts and planned to pad the evidence to align with case law. And to add insult to injury, of course, opposing counsel refused to agree to any exhibits at pretrial. Therefore, the time had to be added on to get each of these exhibits admitted with each evidence. The trial timeline was already tight, 5 days to get all of this done and secure the verdict. Naturally, I was already saying, hey, hello, we need to shorten things up a little bit. You're going to bore these jurors. We had done focus groups and a digital jury survey to hone themes and facts. With the jury research in mind, my role was to keep us on target for these key themes and juror engagement, from jury selectioning, opening statement, witnesses, all the way to closing. The lawyers, of course, whoa, listen, we got this thing. It's going to get appealed. We got to make this record tight. So, of course, that all changed the morning of trial when the schedule went out the window, even before the lawyers had picked a jury. The judge said the case would be completed in 3 days. Hard stop. Despite the lawyers actually on both sides agreeing that they needed 5 days to try the case. But the judge had made his decision. He told the jurors it would 3 days, and he was true to his word. So the team was frustrated, naturally. Understandably, they had built this around 5 days. The opposing counsel had promised an appeal, and now they had 2 or a few days to make it happen. But I wasn't really frustrated because I believe something most lawyers don't, which is a shorter trial can be better. And that's why we had to boogie down and actually do it in real time. So it came down to kind of 3 main things that I want to talk about in this episode. And it's more about what you actually need in your case, getting alignment at a 30,000-foot view for your team and your witnesses, and ultimately how to deliver it once you're on your feet. This isn't new, I promise. I've already been pushing for lawyers to do this for many years, but this goes way back, right? This is about how we be engaging, but also how to check the boxes. And in this trial, the judge just made it non-negotiable for us. So that's where I started with this team before the judge ever said a word. And with that, I told them about their evidence and their outlines. Let's start where I started with this team. Before the judge ever said a word about time, what I told them about their evidence and their outlines. Point number 1, be ruthless about what you actually need. I talk about this a lot on this podcast. Lawyers think they need 20 things when sometimes they can get it done with 3. They see 15 different problems when really there's just 2. I don't know what happens to our brains in law school, but it basically overanalyzes and adds more to the pile. And that happens with every trial I help with, every focus group. They want to put more and more and more. Fewer, okay? All right, so here's what you can do and look at when you want to be ruthless with just what you need. First, you look at overlap. What are the experts testifying to, and what are the fact witnesses testifying to? Many a times there is overlap. And in this particular case, there was more than one expert set up to testify to the same grounds, same facts. When two experts can both speak to a fact, lawyers often want them both to say it. Think belt and suspenders, just in case. But to a jury, that's not extra protection. They're just hearing the same thing twice. And there's actually a real cost to this repetition. Jurors have only so much working memory to spend on tracking your case. Every duplicated fact competes with the facts that actually matter for a limited resource. You're not reinforcing the case by saying it twice. You're taxing the jury's ability to hold it with the rest of it. Think it through here. They have to sit through a whole day worth of evidence. And then you have to hope that you've not overwhelmed them in their short term and their working memory, and then go home when it gets filed away into the long-term memory. So if you're repeating facts and taking up space, we don't want to do that. That's why we really want to be ruthless about what we tell them. The second thing where you can actually duplicate or put too much information is foundational testimony. That just doesn't need to be there. Something we hear over and over again in focus groups is jurors are skeptical of paid experts. They know an expert works for whoever is paying them, and therefore their opinion is biased in that direction. So walking through an expert, their credentials, their entire resume, their years of experience, their familiarity, it doesn't necessarily build credibility the way lawyers think it does. And it doesn't actually matter necessarily to the juror's analysis. Remember, they're walking in knowing, oh, you paid this person? Oh, then they're going to be biased against you. What they're really looking at is, okay, what are the facts that they rely on? What facts did they ignore? How did they do their analysis by taking in these facts, and what was their output? Always knowing that jurors are going to see this in a little bias. Now, don't get me wrong. We got to prove up our experts, but do we need to spend 30 minutes, 45 minutes? I don't think so, right? Get what you need to get there and move on, right? Get to the stuff that the jurors actually want to hear and see. A quick aside here. The insight about jurors and paid experts doesn't come from a hunch. And it didn't just come from this one case. I am hearing it over and over again from over 100 focus groups, actually. And that's what I bring to a trial consult. It's not just running a focus group specific to your case, although that's what we do. It's pairing it with everything else I've learned across more than 1,000 focus groups. Patterns in how jurors think, what they trust, what they dismiss, whether their attitudes they're bringing to your case, to help you craft the strongest case possible, the strongest presentation. If you have an upcoming trial, use the link in the show notes for a free consultation. All right, in order to be ruthless with your material, you have to be extremely well-versed in the case law and what the appeals courts actually require. And trust me, this team was very well-versed, but they were also very worried about needing the extra information and padding in the evidence. But once you have a really good grip on what does the case law say, what do the appeals courts say, and how are they deciding things, then you can actually know what you need to be precise with and what's optional. Because here's the shift in the mindset. You don't get extra points for going above and beyond. And that's with the jury and an appeals court. Think of it like a checklist, all right? Because what happens sometimes if we're actually padding on one particular point, we may be missing a whole nother one. We may have to be doing an exchange here because we're padding one place and not another. So I always like to think of it like a checklist and not bonus points here, because we want to make sure that you are getting everything you need for the record, but you're also could be leaving space for things that need to be added in trial. This always makes me so worried sometimes when we have really long outlines for experts or fact witnesses, is you're not leaving some space for play, because there may be something you need to address. There may be something that comes out in even jury selection that you need to add in, and you want to be able to do that without worrying about the judge jumping up and down, telling you to hurry along. So that's also another really good reason why we want to be ruthless with what goes in. The second thing that I always tell folks is we need to zoom out. We need to go back to that 30,000-foot view, stop thinking witness by witness, and think, okay, if this is our overall view, are we nailing everything down? Where are we duplicating things? But also, are we mapping out with each witness, right? This also helps avoid some duplication, but it's also just being super efficient. What you want to make sure you're doing, and again, I always encourage that when you have a trial and you have a team, you have different lawyers that take different witnesses, right? And we can talk about this, only these lawyers just do damages and these lawyers just do liability. You can talk about that stuff, and that may be a whole nother episode for us. But what I'm actually meaning is when you give lawyers different witnesses, you need to make sure they come and align with what they are doing so that each lawyer feels confident and very comfortable knowing it's going to be covered. The other thing is when you are able to specialize with just one witness, you really know your witness well. You can help the other folks take things off their plate. Oh, I'm covering that. And if it doesn't get covered, you can say, hey, we didn't get to do that. Here, you put it into your outline. And when this doesn't happen, obviously, we have a lot of duplication, and we can have kind of even different themes can come through with different lawyers taking different witnesses. And again, that makes it kind of confusing if we don't have an overall arching theme from jury selection, opening witnesses all the way to close. If it gets a little disjointed, again, we're taxing the juror's memory about things, and they're not really sure what's most important when we kind of emphasize all things as important. This is kind of a strategy point of getting together a 30,000 view, what's going in, what's not going in. It's also kind of damage control, because what you want to be able to do, again, is avoid stepping on each other's testimony, but also being able to change things on the fly. Because if you don't, and you don't have this 30,000 view on the entire team, it's kind of like that scrambling note passing kind of situation where, oh no, they got to get this in, hurry real fast, you're the last witness. And that's not what you want in front of the jury, right? With calm, cool collectedness. Now, the honest version of this in our case was the plan was going in one witness a day, which meant in theory, each lawyer could help and sharpen the next one before they went up. One witness, all of them get to sit in and on the prep. Right? But that gave us, plenty of room to coordinate here. Of course, once the judge cut the schedule, it went all out the window, and everyone was preparing their witnesses on the night of day one because we knew it was going to go fast. And so the coordination was very challenging at that point. Now, you're going to hear at the very end, nobody dropped the ball. We all got things done wonderfully. But I do think that if we do that on the front end, right, beforehand, thinking prep-wise, then it makes it much easier to move quickly on the fly. Now, even when you've done the first two things right, you've cut it down to 100% what is just necessary, and you've taken a step back and looked at that 30,000 foot view to make sure everybody on the team is all in the same cohesive place. This last one, how you deliver things, is also super crucial. So this is really what happens when you get on your feet and you're being engaging with the jury, right? So if you think about it, our first point, definitely we're making our record appeal proof. Second is we're working together to make sure we're not duplicating things. There's no overlap. Everybody feels comfortable with the plan, and there's some cohesion between our witnesses. The last one is let's get our engagement point down. And I would say the number one thing here is organization. Making sure that the outline you have for each witness is organized in an easy way for the juror's brain. But then when you do it in an easy organization, it makes it even quicker to add ways to be engaging. So one of the best ways I have seen to organize direct or cross is our roadmap from Mark Lanier. You have 3 stops along the way. He literally draws a little road and puts a little sign post there. 3s are awesome. We've talked about how easy it is for our brains to, 3 things, I got this. Easy to do, easy to follow, very familiar structure. And if you do this with each of your witnesses, great, the jury is following along. The other thing it does is if they miss a beat, let's say they get lost in their thoughts and they come back, they're not completely lost of where the testimony is or cross-exam is because you're working through the roadmap. You showed it to the beginning, you showed it to the end. Okay, familiar. And they're not getting lost somewhere to go. This also helps if the judge says, this is too much, you need to cut it down. It's just 3 things here, right? It's just 3. Makes it very easy. Also, you know where to compress or cut things when you have a strong organization, and that when it works, especially with all the witnesses. A 3-point roadmap isn't just for the juror's benefit. It's for your own benefit for improvisation under pressure. Think about when you're organizing your outline before you jump to substance and after you, even before you credential the expert, if you have to do that, always be thinking about wanting to tell the jurors, why is this witness here? What is this witness going to help you with? What's their job? Because that will help them know 100% where are we going, because they always want it, like their brains are trying to figure out where are we going. And that also is super engaging in and of itself when you talk directly to them. So it's one of the things I always tell my lawyers what is this person going to help the jury with? What are you going to help the jury with, right? It's very, what? Okay, great. We know where we're going. You've given me a simple outline, and now I know exactly what this person's going to do. Now let's do it together. From there, the engagement part is really thinking through how can we keep a visual going while we're also talking. And that could be just using an exhibit. That could be using a blow up, big demonstrative. It could be a photograph or diagram. You could have the witness come step down and draw on the notepad. You can go up to the giant notepad and draw it. But when we are using a visual and an auditory, right, and talking to them, you're actually making it more memorable. This is called the picture superiority effect. People remember what they see far better than what they only hear, right? So it gets coded into the memory two different ways, visual and auditory. So be thinking about that when, like, how to be engaging. Some people think it has to be something like super exciting. It can be, right? It totally can be, or it can be something as simple, again, it's keeping the eyes moving, keeping a visual at all times, even if it's just your roadmap. That is still helpful and engaging for the jurors. So that's kind of a little bit of the framework. It's super simple. First, be ruthless about what you need. Second, zoom back out to that 30,000 foot view. Coordinate witnesses and the trial team. And finally, organize it in a way that is simple for our juror brains. It can be repeated. And then also move into that engagement piece of things within that organization. In this trial, the jury came back with 3.4 million. Woohoo! And they told us afterward they used our numbers to calculate the verdict, which is exactly what you want to hear, right? So they're paying attention. They were very engaged in what was going on. And again, it was done in 3 days. So here's my takeaway overall. Like, the judge made a decision on day one that felt very much like a threat. But it really wasn't. It was just a preview of what trial could look like every time if you build it this way from the start. Speed trials, compressed trials, that is the way to go. That is what jurors are expecting. Their attention spans, not necessarily shrinking, but their patience totally shrinking, right? They want things done. And what's been happening many a times is jurors are giving up days, hours, weeks of their life, and in return, they're getting just these trials that are just packed with hours and hours of duplicative testimony that just doesn't need to happen to get the verdict. And this case is just one data point. Trust me, I'm not the only person. Joe Free, there's lots of folks talking about doing compressed trials, doing a speed trial. And the verdict after verdict comes in that you can still be thorough and be persuasive. You can do it in less time than you think. And that's one of the best ways that I work with lawyers is it's easy for me to say this as somebody who doesn't necessarily get on my feet again in front of the jurors. However, when I help lawyers do this, I can see the success happen. We get in our heads that we may need more. We need 10 points. You don't necessarily need all the 10 points, and focus groups can help you get there. So if you have an upcoming trial and you're curious about how to work with me, book a call with a link in the show notes. All right. Thank you so much for listening to this episode. Keep on prepping to win.